599, 1995. In Section 1505, the nexus can include a connection to a pending federal agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. ID at 599. See also Arthur Anderson, LLP v. United States, 544 U.S. 696 707 708, 2005. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. 18 U.S.C. 1515 A1A. For the purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. 18 U.S.C. 512 F1. Although proceeding need not already be in progress to trigger liability under Section 152C, a nexus to a contemplated proceeding still must be shown. United States v. Young, 916 F3D 368 386 4th Circuit 2001 19. United States v. Petrick, 781 F3D 438 445 8th Circuit 2015. United States v. Phillips, 583 F3D 1261 1264 10th Circuit 2009. United States v. Reich, 479 53D 179 186 2nd Circuit 2007. The nexus narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. Aguilar, 515 U.S. at 600. Internal quotation marks omitted. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful. Aguilar, 515 U.S. at 60162. Emphasis added. Internal quotation marks omitted. The endeavor must have the natural and probable effect of interfering with the due administration of justice. It at 599. Citation and internal quotation marks omitted. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. Petrick, 781 F3D at 445 446. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. United States v. Martinez, 862 F3D 223 238 2nd Circuit 2017. Brackets, ellipses, and internal quotations omitted. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly or with an improper motive. United States v. Richardson, 676 F3D 491 508 5th Circuit 2012. United States v. Gordon, 7110 F3D 1124 1151 10th Circuit 2013. To act corruptly means to act with an improper purpose and to engage in conduct knowingly and dishonestly with a specific intent to subvert, impede, or obstruct the relevant proceeding. Some quotation marks omitted. C. 18 U.S.C. 1515b. As used in Section 1505, the term corruptly means acting with an improper purpose, personally or by influencing another. See also Arthur Anderson, 544 U.S. at 705-706, interpreting corruptly to mean wrongful, immoral, depraved, or evil, and holding that acting knowingly, corruptly, in 18 U.S.C. and 1512b requires consciousness of wrongdoing. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and rights of others. Ballantyne's Law Dictionary, 276, 3D ed. 1969. C. United States v. Pasha, 797 F3D 1122 1132, D.C. Circuit 2015. Aguilar, 515 U.S. at 616. Scalia J. Concurring in part and dissenting in part, characterizing its definition as the long-standing and well-accepted meaning of corruptly. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. See 18 U.S.C. and 1512b 1, 3, making it a crime to knowingly use intimidation or corruptly persuade another person or engage in misleading conduct towards another person with intent to influence, delay, or prevent the testimony of any person in an official proceeding, or to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a federal offense. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. United States v. Edlin, 887 F3D 166 174, First Circuit 2018. United States v. Parks, 791 F3D 1188 1191 1192, 10th Circuit 2015. United States v. Byrne, 435 F3D 16 23 26, First Circuit 2006. United States v. Lachey, 417 F3D 715 718 719, 7th Circuit 2005. United States v. Burns, 298 FD 523 539 5440, 6th Circuit 2002. United States v. Pennington, 168 F3D 1060 1066, 8th Circuit 1999. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons. Sparks, 887 F3D at 174. Corrupt persuasion is shown, quote, where a defendant tells a potential witness a false story, as if the story were true, intending that witness to believe the story and testify to it. United States v. Rutherford, 786 F2D 7782, 2nd Circuit 986C. United States v. Gabriel, 125 F3D 89 102, 2nd Circuit 1997. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. See Lachey, 417 F3D at 719. Corrupt persuasion can also be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with the law enforcement. See United States v. Schatz, 45 F3D 1289 1310, 11th Circuit 1998, telling secretary not to say anything to the FBI, and she would not be bothered. When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a proceeding inquiry articulated in Aguilar, that an individual have knowledge that his actions are likely to affect the judicial proceeding, 515 U.S. 599, does not apply, because The obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing. Arthur Anderson, 544, U.S. 705-706, declining to explore the outer limits of this element, but indicating that an institution was infirm where it permitted conviction even if the defendant honestly and sincerely believed the conduct was lawful. It is an affirmative defense that the conduct consisted solely of lawful conduct, and the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. 18 U.S.C. 1512C. Attempts and endeavors. Section 1512C2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. See United States versus Resident Ponce, 549 U.S. 102, 106, 107, 2007. The act must be substantial in that it was strongly corroborative of the defendant's criminal purpose. United States versus Pratt, 351, F3D, 131, 135, 4th Circuit, 2003. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. United States versus Irving, 665, F3D, 1184, 1198, 1205, 10th Circuit, 2011. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. Model Penal Code 5012G. See United States versus Lucas, 499 F3D 769 781, 8th Circuit, 2007. The Omnibus Clause of 18 U.S.C. and 1503 prohibits an endeavor to obstruct justice, which sweeps more broadly than Section 1512's attempt provision. See United States versus Sampson, 898, F3D, 287, 302, 2nd Circuit, 2018, United States versus Leisure, 844, F2D, 1347, 1366, 1367, 8th Circuit, 1988, collecting cases. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. United States versus Davis, 854, F3D, 1276, 1292, 11th Circuit, 2017. Internal quotation marks omitted. B. Investigative and evidentiary considerations. After the appointment of the special counsel, this office obtained evidence about the following events related to potential issues of obstruction of justice involving the President. A. The President's January 27, 2017 dinner with former FBI Director James Comey, in which the President reportedly asked for Comey's loyalty 1 day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B. The President's February 14, 2017 meeting with Comey, in which the President reportedly asked Comey not to pursue an investigation of Flynn. C. The President's private request to Comey to make public the fact that the President was not the subject of an FBI investigation, and to lift what the President regarded as a cloud. D. The President's outreach to the Director of National Intelligence and the Directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russian investigation. E. The President's stated rationales for terminating Comey on May 9, 2017, including statements that could easily be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination. And F. The President's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and omitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information and our analysis of applicable statutory and constitutional principles discussed below in Volume 2, Section 3, Infra, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the President. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information, and we interviewed other witnesses who had pertinent knowledge, obtained documents on a